Good afternoon. My name is Joey Leiner, Chair of the LeadsCouncil and also Chief Revenue Officer of Digital Media Solutions. On behalf of LeadsCouncil, the Executive Director Rob Seaver, and the entire Board of Directors, I want to welcome you all to today's webinar, Generating Leads Legally, brought to you by LeadsCouncil and the law firm Venable, LLP. LeadsCouncil's mission is to maintain a trusted association of vendors, buyers, and sellers adhering to industry best practices. We promote and protect the growth of performance marketing through establishing and managing the ethical standards and guidelines regarding online performance marketing through self-regulation, education, and government association advocacy, lobbying on behalf of those members. Please feel free to check out more at our website, leadscouncil.org, or follow us on Twitter and handle LeadsCouncil. Venable is a nationwide law firm that provides legal counsel to the LeadsCouncil and many other advertisers and marketers throughout its offices in Washington, New York, LA, San Francisco, and my hometown, Baltimore, Maryland. At LeadsCon, we had a great set of sessions at Buyers and Sellers Summit, including a regulatory fireside chat with the head of the FTC Bureau of Consumer Protection, and today's session cover that and a lot more. I know that Dan Blinn, Steve Freeland, Alex McGarris, and Jonathan Pompin have a lot of experience and insights to share. I'm now going to turn it over to my good friend Jonathan. I'll let you take it from here.
Thanks, Joey, and we'd like to thank the LeadsCouncil for helping us support this webinar today. Today's webinar is Generating Leads Legally, Regulatory and Litigation Quick Hits. And before we get started, just a couple housekeeping notes. We will take questions from the audience, so if anyone has questions throughout, please feel free to use the interface on your screen. And today's session is also for CLE, Continuing Legal Accreditation. For those of you who are attorneys and seeking CLE credit, you'll receive an email after today's session, roughly about an hour to a day later, with forms to fill out. And appropriate information. We will also provide a verbal code at the end of today's session for CLE credit. And of course, today's session is just a summary of the issues. It doesn't represent the opinions of Venable Law Firm, LeadsCouncil, or our clients, and is merely for educational purposes. And so today I am joined by my colleagues and partners, Dan Blinn, Steve Freeland, and Alex McGarris. All of whom work with advertising and marketers in lead generation and related matters, both from a defensive standpoint in government investigations and enforcement matters, to compliance matters, and of course the tag team of Steve and Dan work closely on defending class action and private lawsuits, particularly in the telemarketing and TCPA area. Whether you're at generating leads or purchasing leads, the Federal Trade Commission plays a significant role in regulating advertising and marketing practices, and its evolving work in the lead generation space and its focus on lead generation ever since a workshop, and even before that, on lead generation in 2016, has been an extreme focus for enforcement and really regulation through enforcement, as well as education activities that they've done to the business sector and also through to consumers. There's also other federal and state regulatory consumer protection priorities that are evidenced by the work of the Consumer Financial Protection Bureau, other federal agencies, and state attorneys general, as well as also for those in the consumer financial services space, state banking and financial services regulators. And of course, the one topic that we certainly could not do a webinar on without including is the Telephone Consumer Protection Act and the private right of action under that wreaks havoc for legitimate advertising and marketing practices, both by those generating inquiries as well as also those trying and seeking to deliver the services that consumers are seeking. And we'll also discuss today, of course, strategies for enhancing compliance and avoiding legal pitfalls. There's no shortage of tips and best practices, and collectively we'll be discussing those today. But to start with, You know, as Joey mentioned, just 3 weeks ago at the LeadsCouncil's Buyers Sellers Summit at LeadsCon in Las Vegas, there was a panel session that we facilitated, and Alex, that you moderated, with the head of consumer protection for the Federal Trade Commission. And their mandate is to protect consumers against unfair, deceptive, or fraudulent practices. And they've taken an important role in discussing lead generation, advertising, and consumer protection issues. The Bureau enforces a variety of consumer protection laws. And Alex, you really had a terrific conversation with Andrew, a fireside chat, where the focus was very much what the FTC's been doing in the space, as well as also where it's headed. What were some of the takeaways, and what was the session from your perspective?
Sure. So thanks, Jonathan. And as Jonathan mentioned, I had the privilege at the Buyers Seller Summit at LeadsCon a few weeks ago to moderate this conversation with Andrew Smith, where he was, I think, surprisingly or refreshingly frank with the audience and with me in answering questions. And as I'll discuss in a little bit, he struggled a little bit in answering some of the pointed questions that came from the audience on, taking the kind of lessons learned from cases, enforcement actions that the FTC has brought and that he highlighted during his remarks, and putting them into practice. But first, let's take a step back. Next slide, please. Who is Andrew Smith? Why the focus on the FTC in this presentation? And every time you participate in one of these webinars or conference panels, obviously the FTC is always top of mind. So first and foremost, the Federal Trade Commission, independent federal agency. It's led by 5 commissioners. It's a bipartisan group, and for the first time,
that's a unique group, right? The commissioners, because you're about to say, I think, that they're brand new, but it's also a diverse group because you've got 3 Republicans and 2 Democrats, but fairly united on consumer protection matters.
Even more basic than they're all new, the seats are filled. It's been years since all 5 seats at the commission have even been filled. So these last few years, you had a situation where, one, things were very slow, and there was a lot of paralysis because of the constant exiting of commissioners. And then you also had I think at one point there was 2 and then 1 commissioners at the helm. Things moving really, really rapidly because you didn't need consensus, which is how the commission, which has been in existence for over 100 years, it was designed to be a deliberating body, with 5 members, and yes, on a bipartisan basis. And so the current composition, you've got 3 Republicans, 2 Democrats, very different background and experience. I think all but 1 really don't have any traditional consumer protection experience. You have Rohit Chopra, who is one of the Democrats on the commission. He comes from a very strong consumer protection background. The others more strong on the antitrust, anti-competition side of the House. But as you mentioned, all pretty united in terms of a focus on consumers, which is the FTC's mandate, and also using the FTC's power, authority, the tools in its toolbox in a really effective way. The FTC's jurisdiction is very broad. The FTC Act, which is the statute that gives it its powers, gives it very broad jurisdiction to enforce what's called Section 5 of the Act, that bans, deceptive and unfair practices and acts in interstate commerce. And that basically would cover any business or person except for, very specific entities that are carved out, like banks, airline carriers, et cetera. And in addition to that mandate to prohibit unfair and deceptive practices, there's also a handful, dozens of other statutes and regulations that it writes itself that it enforces in the consumer protection space. Next slide, please. The FTC itself is divided into two bureaus, the Bureau of Competition and the Bureau of Consumer Protection. And this brings us back to Andrew Smith, who was at LeadsCon. He is the head of the entire Bureau of Consumer Protection. And that bureau itself has a handful of divisions that are listed on the right-hand side of this slide, plus 7 regional offices. About 450 full-time employees roll up to Andrew. And the way the divisions are broken out, and there's a handful on this slide, including the Division of Advertising Practices, the Division of Financial Practices, of Marketing Practices, of Privacy and Identity Protection, all of which touch lead generation. And this was something that Andrew emphasized in his remarks because, lead generation itself touches so many, facets of what, he considers to be, within his, his boundaries. And so there's the privacy side of it, the collection of personal data, the storage of it, the sharing of it. That is a very, obviously a very hot topic nationally, but that's something that the FTC has primary jurisdiction for governing and policing. The Division of Financial Practices, although they don't have authority over banks, all non-banks that are in the lending space, selling leads, buying leads for, lending products, other credit products. The Division of Financial Practices is very active, and we'll talk about one of the cases it brought soon. And of course, marketing practices, which is looking at dietary supplements, other very specific verticals, and very specific practices that all relate to lead generation. On the next slide, we'll talk about, the takeaways. And Jonathan, you were there. I'd love to hear what you think too. But first, Andrew emphasized, although the commissioners are all new, meaning about a year since, 4 out of the 5 came on board, and they're still learning the ropes, they all are very committed to rigorous enforcement, and that is bipartisan. A lot of, prognosticators when Donald Trump was elected president had predicted that there would be a much more, laissez-faire, business-friendly version of the FTC, and we just haven't seen that. And I think there's a couple of reasons for that. One of which, of course, is that the new leadership is relatively new, but we've also, since watching, observing how the new commission and the new chairman, are going to be using their power. They've decided, to effectively use the resources to bring, cases that have a strong deterrent effect, and that means when they decide to bring a case, they're bringing, the full load of their power behind it. And we're seeing I think we're seeing fewer cases, but we're seeing, still very large monetary judgments, very powerful injunctive provisions. Oftentimes you're seeing them still trying to, completely shut down operations, and we'll talk about one of those cases. Second, Andrew made clear that the FTC, it does have, the ability to write rules. It's got a, rulemaking shop. There's a lot of education and consumer advisory opinions and guidance, but really it is a law enforcement body. That's what they do. They hire litigators, and they bring cases that they are prepared to litigate, and they're not afraid to litigate. Third, with respect to lead generation, specifically transparency with the consumer, with the lead, is the key. And we'll talk about the ways that manifests, whether we're talking about, using, AdWords for Google, the domain names that you select for your websites, what's on the website, what, consumers think that the lead form is going to happen when they submit information in the lead form, and then, when they start receiving emails and phone calls, what they're told. And then, with respect to compliance, which we'll talk about at the end, doing due diligence on your buyers, on your sellers, on the folks that are going to be conducting the telemarketing calls, ensuring that you know who you're working with is going to be really important, because the FTC will go after any party in the transaction that it can find. And so if the bad actor is the telemarketer, but the FTC decides it's easier to go after the website owner, it will, because you're in a relationship with that telemarketer, and they have very broad authority to hold parties accountable for other parties, business partners' activities. Next slide, please.
Yeah. And I thought, Alex, what was really relevant with the conversation, and of course there was the second panel with Andrew Smith on the following day too at LeadsCon, was the idea that they have a patchwork, that is the Federal Trade Commission, has a patchwork of statutes in addition to just its broad authority under the FTC Act, and it's able to deploy a variety of enforcement hooks when necessary. So it may be that and in fact, because of those different divisions within the Bureau of Consumer Protection, it may be that the focus in one case is telemarketing, in another investigation it may be email marketing, and another it may be the buyer's conduct. But the sum total is that there has been a slew of cases and certainly even more investigations that many people would not even know about necessarily, although, again, I think they are making a concerted effort that when they even bring an investigation, there's a reason for it, other than in some cases historically there's been some sweeps. But what they'll do is they will look at the facts, and that they have a really wide variety of tools available to them, whether it be the telemarketing sales rule, which has hooks for do not call, in addition to a variety of advertising and claim substantiation through telemarketing that needs to be there, material terms and conditions and consents, to matters related to consumer financial services laws, where they can bring those to bear and couple that with the Federal Trade Commission Act, which gives them broad authority to go after deceptive and misleading practices. And I know, Alex, you had selected one of the examples that Andrew brought attention to that illustrates that.
Right. So I think the most important recent case the FTC has brought in the lead generation space is the one against, the website was Army.com and EnlistArmy.com. And Andrew spent a lot of time focusing on this case, and I think it's because the FTC really touched on the entire, flow from how the consumer was first identified all the way through the telemarketing, and I'll go through it here as well. This case was brought by the Division of Financial Practices because it's in, the education space, but there was a network of websites that were targeting people that were seeking to join the armed forces, and so folks that were entering into search engines terms like enlisting, Army Reserves, U.S. Army, they were getting served the ability to click on this website, which this one up on the page is ArmyEnlist.com, but they also owned Army.com. And the sites were designed to look like they were recruitment sites. This was a big focus in the FTC's complaint and in its press release. So not only were the sites and the operators of the sites, through it, their AdWords targeting folks that were looking to enlist, but then the site itself continued that kind of affiliation or representation that these were sites to collect information for folks that were interested in enlisting. And so the lead form itself kind of suggests that you'll be contacted by potentially a recruiter. And throughout the website, words like contact a recruiter, get information about joining, the various web pages, and even if it included real information about how to contact recruiters, et cetera, the fact was that was all designed to look like this is a recruitment site. And once you entered your information, it talks like, are you ready to talk to a recruiter? There was no disclosure or any type of obvious information about, where this information was going. And in fact, there was a representation that we will not, share your information with third parties. Once you entered your information into the site, then you will receive telephone calls, and the telephone representatives would continue the representation that this was in affiliation with the military services. In fact, the training that the FTC reviewed says, just to make sure that folks don't hang up the phone when they pick up, start with, this is Navy.com, or, this is Navy, and then slow down, and then, calling for John about, and then soon the pivot to a pitch for education would begin. And so the leads were actually sold to secondary education shops that were looking to recruit students that also would be getting benefits, enrolling in the military and getting benefits to attend post-secondary school. And so the FTC brought an enforcement action saying that the entities, the owners of both the websites and the telemarketers, violated the TSR, Telemarketing Sales Rule, and the FTC Act for deceptively representing affiliation with the U.S. military when there was none. And as part of their order, they were banned from making these misrepresentations, but they also had to turn over their websites, which you can imagine were very valuable properties, Army.com. And so the FTC, as Andrew said a few weeks ago, they still haven't figured out what they're going to do with those sites. Maybe turn them over to the military to use themselves, or some sort of just discontinue them so that you can't, so others can't use it in that way. But I think for me, the takeaway for this case is that the FTC is not looking just at the lead form and the language around the submit button. They're looking at the entire process, the entire from the consumer's perspective. So what are people entering? What search terms are people entering to get to your website? What's the website's domain name? What's the net impression of all the text and graphics on the website, the various web pages? And then, of course, what are you telling consumers about what's going to happen to their data? And I think that's ultimately, the most important thing is that you're transparent to consumers on that front. The other, cases that the FTC has brought emphasize, one, making deceptive claims to consumers in order to induce them to submit their information are always going to be a problem, and the FTC will continue to look at all the parties in the transaction. The publisher, an affiliate network, a service provider like a telemarketing service provider, and the ultimate, end user of the lead are all on the hook. Andrew emphasized that throughout, and part of that is, again, to serve as a deterrent. And part of that is just practical. In some cases, the FTC can't get to all the parties, or can't find, can't identify. It's not apparent to them who's behind a telemarketing operation of things or who's the owner of the website. But when they can get to some parties, they will, and they, prefer obviously to bring in all the parties when they can. They also, although they have not brought any very recent cases. In 2017 and 16, they brought a slew of cases under their unfairness prong, concluding that the way data was collected from consumers and shared with third parties was done unfairly because consumers were not told what would be happening to their data, and there was no way for them to protect themselves from bad actors that accessed their data. And so there was a slew of cases designed to shut down, phantom debt collection. So, folks that were receiving phone calls about debts that didn't exist, their information had been, disclosed from various brokers that had information from, a lead generation site that consumers were clearly in debt. And Jonathan, I know you want to talk a little bit about marketplace lenders and the FTC's involvement there.
Yeah, consumer financial services is an area that on the federal level, the Consumer Financial Protection Bureau has been getting a lot of attention on. But even still, the Federal Trade Commission has been extremely active in bringing attention to bear on marketplace lending and other small dollar loans and personal loans, and we'll also talk about in a moment small business loans. But going back even just to the last few years with the marketplace lending really taking off in the public's eye, the FTC has drawn attention through a 2016 workshop where they drew attention to marketplace lending, had gone through over 20 different marketplace lending websites at that workshop and identified a variety of different features, in air quotes, that they saw. And then lo and behold, just about a year after that, started to bring enforcement actions around issues that were brought to bear and light was shined on at that workshop. And so the generating of leads for loans continues to be a focus. And Alex, as we heard, Andrew Smith is a former consumer financial services attorney, or not even a former, because I think he still very much considers himself one. And with that as his background, there's certainly no way that the sort of lending and consumer financial space is going to escape attention in the next several years. And even with the CFPB online, there is certainly attention that is being brought by the FTC. And that actually started going back to 2016, where the FTC did a workshop on lead generation. And Andrew touched on this too in both sessions at LeadsCon and LeadsCouncil's Buyer-Seller Summit, where up until recently, the activities related to lead gen and the focus at BCP in his shop were really focused in the financial services sector, with the other areas sort of being tangential, because in the education space and in the small dollar lending space, that's where they were seeing the most activity related to lead gen and doing very active investigations. And so this workshop came out of financial practices. But that's now, the learning there and the focus and attention has spread amongst his colleagues, amongst the staff, and we're starting to see now that happening in the focus in other areas. Now, the takeaways from the workshop, not surprisingly, are very similar to the takeaways from Andrew's comments, and I think very much would reflect the best practices that we would advocate too when working with folks on compliance and certainly in defending matters in investigations. That's to disclose clearly to consumers who are and how you will share their information. Sensitive information, certainly, but even just the mere email address and contact information, what's it being provided for, and are you getting consent for it? Monitor the lead sources for deceptive claims and other warning signs. Andrew really pushed on this, that buyers have a responsibility to understand what lead generators are saying about products and services, whether it's their products that are being advertised or just a generic statement about products, services, or benefits that could be achieved by making an inquiry. And vetting buyers on the seller side to avoid selling leads to buyers who are either non-compliant with laws that apply to their products and services, or perhaps just incompatible with the lead that's being generated. That's an issue certainly with remnant leads to buyers with no legitimate needs for the sensitive data that may be collected, but nonetheless, a seller is looking for a monetization path. And sensitive data being kept secure, I think, is certainly always the case, but something that was really brought to attention in some of the enforcement actions over the last several years, where data not just was sold, but in some cases was stolen by employees and others at lead generation organizations. And in some cases, that information was not just name and contact information, but banking information, social security numbers, and the like, that could lead to identity theft, debt collection issues, and others for the consumers. All of that is to say that there is a big focus on all of the different areas of consumer protection that the FTC has, and that's something that certainly permeates other areas as well. Now, as I mentioned, the FTC in May is having a session on small business financing. And small business lending is an area that is starting to get a lot of attention in the marketplace. And the FTC has identified a need to draw attention to it from a regulatory and enforcement standpoint. So they're going to be examining the trends and consumer protection issues in small business financing, including what they're seeing as being a proliferation of, quote, online loans and alternative financing products. And what that really stands for is that they know that online there's a lot of activity around small business financing. And just like they put the spotlight on marketplace lending, they're going to put the spotlight and probably enforcement attention on small business financing. And so it's an important area, particularly for folks that are in that space or thinking of going in that space, to recognize that just because the FTC is frequently thought of as a consumer protection agency, and we certainly have referred to it as such, they do have the ability to regulate and enforce laws that they do in the consumer space with respect to both small business lending and other small business offerings, and in fact have a very long track record of doing so. Now, there's also other federal and state regulatory consumer protection priorities that are out there. We don't want to give those short shrift today. And I know, Alex, one of the things that you certainly have been keeping an eye on is what's happening at the Consumer Financial Protection Bureau, which I think a lot of people have thought as being a bit of a 2.0 or 3.0, depending on how one thinks of it, in terms of where they're at in doing regulation through enforcement and regulating advertising and marketing practices related to financial services.
Yeah, I mean, we're seeing the CFPBs recently bringing more cases. There certainly was a period of time between acting director Mulvaney's tenure and you know, current director Kreininger's you know, the vote that got her in. That there was a lot of the CFPB was, you know, taking a look at all of its policies and practices and reevaluating processes internally. It seems like they've, you know, come out of that review period and now are, you know, operating under a new business as usual, and we're seeing more and more cases. You know, small dollar lending is still a very, you know, high priority at the Bureau and debt collection, and we're seeing them bring in more and more cases, including, you know, opening, you know, bringing back, you know, their investigations that had been on hold for a long time. And a lot of the focus on these cases are, you know, more traditional advertising than trying to kind of, you know, regulate, you know, the financial product itself, which was obviously a very big priority under the Cordray administration. And so I think what we can, you know, be sure in the future is that we're going to see a lot more enforcement from the CFPB. But I also think that in terms of their general view about the industry, you know, and the financial verticals that heavily rely on online lead generation, you're not going to see the same emphasis that the prior administration had on holding the lead generators and aggregators accountable for what the lenders did or did not do, or the licenses they had or had not had. I mean, I think that, you know, that we'll see if that's the case. That's my, you know, that's my feel right now.
And that's an important point because, you know, at the state level, there's certainly no shortage of developments too, where you have, whether you have in California or in Vermont and Connecticut and other states, a lot of emphasis on trying to wrangle and in some cases push the boundaries of what is a broker or in some cases some legislative activity around actually creating carve-outs or specific licensing categories for, quote, lead generators or finders. And in California, the Consumer Finance Lenders Law, there's been legislative activity there in the last session and in the current session. There's been enforcement as well there by the California DBO, and in Vermont there's been activity in several other states too. Connecticut has licensing for mortgage lead gen related activity, and other states have continued to be active in that space. Licensing for mortgage lead gen activity and is often expected, if not by the regulator, by the buyer, and going through diligence through that process. And as Alex mentioned, at least in the consumer financial services space, the CFPB has shown the ability to bring in underlying compliance with state law as an issue, whether it be from a substantive standpoint or just from an advertising and marketing standpoint. If someone's advertising that they can provide a particular service, that implicitly would mean that they're legally doing so, and that's been the rub even before the CFPB took some of its aggressive actions in the lead generation space. Now, all eyes, too, are also on California and the California Consumer Privacy Act, which is going through a regulatory rulemaking and takes effect in 2020. But you've got quite a lot of activity there. Perhaps the story isn't completely written yet, but nonetheless, there is a lot of attention on what could be significant regulatory requirements around the collection, use, and transmittal of consumer data related to Californians, and has many vestiges and influences from the GDPR regime in Europe and the EU, and has the potential for spreading across the country. Certainly, the concepts that are there are popping up in other legislative proposals. Consumer groups are pushing that, and there's no shortage of debate in the public policy arena around what is appropriate regulation of consumer data collection and use and sharing practices, all of which could have a profound effect. But the reality is that there's some very core compliance requirements that one needs to take into account today to avoid legal risk, and I think also bake into the system in planning for future use too. Oftentimes we think of this as a snapshot in time, but with lead generation and the collection of consumer data, information that's collected today may certainly be used years from now, if not longer. Now, states attorneys general is another hot area, and that's an area that transcends, of course, all advertising and marketing and all different types of products and services. Historically been very active in the areas of education advertising, general advertising for household goods and services, consumer lending, and other areas. And we continue to see single state and multi-state investigations in that area, and stemming from both consumer protection concerns as well as also specific marketing practices related to particular channels, including telemarketing. And so that brings us to our tag team today of Dan Blinn and Steve Freeland, who on a day-to-day basis both advise and defend enforcement actions and private lawsuits in the Telephone Consumer Protection Act arena and generally around telemarketing. Now, Dan, at base, when we always talk about this, it always seems simple. Full and clear disclosure and consent should rule the day, but people quibble about what that really means, right?
Yeah, I'm actually going to let Steve handle this answer, but before he does, you know, as Jonathan mentioned, we're now talking about the use of the telephone, or anyone who uses fax would also this would also apply to them, but we're talking about telephone communications right now, text or calls, and for those on the phone who are lead generating but only using web forms or selling leads and the like, you still need to pay attention here because there are theories of vicarious liability that have been extended in FTC enforcement actions under the Telemarketing Sales Rule, which we'll talk about, and the Telephone Consumer Protection Act, which we really will talk about given that it's got a private right of action. We've seen both agencies and plaintiffs in court take the view that selling lead data, if you know that it's going to be used in a manner that violates either the TSR or the TCPA, you can be on the hook for that as well. So don't put us on mute or turn the volume down if you're not using the phone, because you may find what we're talking about applicable.
Right, and so with that, good afternoon, everyone. I'm Steve Freeland. Dan and I have been doing this for quite some time now, and have a good feel for both where the regulators are heading on this and have headed, as well as the class action plaintiffs bar, which can be a bane for some of our clients' existence. And so Jonathan and Alex already covered some of the concepts here that are on the screen, and they're back up there again because they're so important that we have to reinforce that this is sort of the threshold issue if you're generating a lead. If everything from the start on your consent is bad, then everything that comes after it is also bad. You know, we can harken back to stories about fruits of the poisonous tree. The same thing happens here, okay? And so we advise a lot of clients that generate leads in a lot of ways, a lot of folks doing it online, as I imagine a lot of the folks on the phone do. And I want to start with sort of a real-world example to talk about what some of these concepts on the screen mean. Let's assume that we have a lead generator who's generating leads through Facebook for discounted vacations, okay? But it's also a co-registration page. So their main offer is a discounted vacation, but they're also generating leads for folks that do car insurance and sell hearing aids and sell home security systems, okay? Sort of the gold standard of having valid consent there, and this goes back to what Alex was talking about in her Fireside chat with Andrew Smith, is it's going to be generally okay for you to collect the phone number and get the consent for all those folks as long as your funnel is clear. So if a consumer lands on the Facebook offer and says, I'm very interested in the vacation, and clicks on the button, then they go to a next page. And let's say it's a 3 or 4 step funnel till they get to the submit button. What we've been encouraging clients to do is go ahead and disclose those other verticals early on in the funnel process, such as, you know, we've got these great offers on vacations. You know, tell us when you want to leave. Tell us where you want to go. We've got vacation deals for the following cities. You know, pick one. Oh, and by the way, we're also going to give you some great information on these other offers about, you know, hearing aids or home security systems or car insurance. Wouldn't that be great? Then by the time they get to the submit page, where they've got, you know, you've got your magic TCPA language in there, in that language, you actually disclose who those other partners are by name that are going to be calling about the other verticals. That's the gold standard. And it's very hard, if that's all done in a very clear and conspicuous way, it's very hard to say that consent from that consumer is going to be invalid or otherwise not clear and conspicuous because you've disclosed everything to them along the way. And an important thing to keep in mind, you don't have to be married to the legalese. And this is something that we work with clients all the time. You can get the requisite consent that you need and still market at the same time. There's a way to do it. There's a way to thread that needle, and that's where we try to work with clients to get them the compliance that they need and make all these disclosures, but also do it in a very marketing-friendly way. And so that's sort of right here at the outset, a high-level example of what we're talking about here, sort of taking these general rules and applying to a real-world situation. So that leads us to the next slide, which is these are sort of the other core issues that come up with respect to TCPA compliance. And for those on the phone that don't know, I just want to hum a few bars about the TCPA. I'll never admit this in court if I'm arguing a case, but the pleading standards are relatively low for a plaintiff, and the class actions can be relatively easy to certify, which is why they're problematic, especially given the $500 in statutory penalties that applies per violation call or text. So if you've got one campaign that goes awry, for example, that let's say you make 10,000 calls, that number gets really big really fast, okay? So that's why it's important for the compliance on the front end to reduce the exposure on the back. And so these are the issues that come up routinely for us. And one of the main drivers of the types of consent that you need to get is the type of call that you're making. Are you calling to market something, or are you calling to just give them information about an existing account? For those on the phone, it's probably more on the marketing side than it is on the informational side, which means a higher level of consent is going to be needed. And then the other issues that pop up occasionally are what's called revocation of consent, and what that means is a consumer can provide you consent today to receive all kinds of telemarketing calls and about all kinds of different verticals and all types of different products. They can turn around tomorrow and revoke that consent using any reasonable means. And once they revoke, you've got a certain amount of time, generally 30 days, to honor that request. And then calls or texts placed to them after that would be violation calls. And then we're also dealing with some, Dan and I actually have a current case right now dealing with some new technology such as soundboard technology for, this is also called Avatar for those on the phone, which the plaintiff's lawyers are starting to go after as well. So, and so this next slide gets into, okay, so what is a telemarketing call? Let me start with what's not a telemarketing call. A bank sends an automated text message to one of its customers saying, "We have an alert for you. It looks like someone's trying to hack into your account." That is not a telemarketing call or a telemarketing text. Now, same text. Someone's trying to hack into your account, and oh, by the way, call this number and get great information about a new loan for that new boat you've been wanting. That is now a telemarketing text, which requires the higher level of prior express written consent, which we'll get into in a little bit. But this is the point that telemarketing is broadly construed by the courts. If it's what's called a mixed message, which is the example I just gave, it's both account or informational related as well as trying to market another loan, then the higher level of consent is needed.
Yeah, and err on the side of caution. I mean, you will be thoroughly confused if we do our job, you'll be thoroughly confused by the end of our presentation as to what is compliant and what's not compliant. An ounce of compliance right now will save you a pound of TCPA liability later. The TCPA is a real minefield. So, we're going to give you kind of the issues, but we always recommend consulting legal counsel. It doesn't have to be a long call, but a lot of times, thorny issues can get sorted out very quickly.
That's right, and a lot of this stems from the type of technology that you're using to make a telemarketing call or send a telemarketing text. And so we have here on slide 23 sort of the key issues that are the drivers of liability. Manual dialing, for all intents and purposes, with a live operator, very low risk, and only really need to comply with the do not call rules and scrub your numbers against the do not call list. If you're using any form of automated technology or a pre-recorded voice, we're now into a higher level of potential liability. And so what are these technologies? Okay, so I'm sure everyone that's on the line has heard at some level about ATDS and Autodialer, and there's been a lot of case law movement or a lot of movement in the industry as to what it is and what it isn't. So for years, the definition was very broad, and it included even text sent from iPhones, right? And that's because the FCC said, well, it doesn't matter if it's used in an autodialer fashion. If it has the potential capacity to be used in an autodialer fashion, that's sufficient. The D.C. Circuit, which is a court here in D.C. that oversees the FCC's rulings, said, nope, that's a dumb rule. You're finished. We're setting that aside. And so what we've been seeing now in the last year or so since that decision came down are courts wrestling with just what the statutory definition of autodialer is. And fortunately for the folks on the phone, a lot of the courts have said, well, looking at the statutory definition, it's pretty simple. It's got to have the current capacity to generate random or sequential numbers and then dial those numbers. What does that mean? If you're dialing from a pre-existing list of numbers that you've generated through lead forms online or through customer lists, that's not an autodialer because those numbers are not generated random or sequentially. So that's very favorable for industry right now. Here's the rub. The FCC, in their infinite wisdom, has decided that they are going to come up with a new definition of autodialer in light of the D.C. Circuit setting aside their old one. And so we all wait with bated breath to see what that definition is going to be and how it may be different from what the courts are currently holding in terms of really cabining in what is an autodialer.
Yeah, let me take a bit of a contrarian view. So Steve has mentioned, if you're dialing from a list and not randomly or sequentially generating the numbers you're calling, yes, there are certainly courts that have found that recently that is not an autodialer. There are courts that have gone the other way. On the Ninth Circuit, if you're out in California or Nevada or Washington State, dialing from a list is enough right now to be an Autodialer, even if it's a list of numbers that you have cultivated. In the Third Circuit up in New Jersey and Pennsylvania, I think Delaware as well, Steve's right. There, dialing from a cultivated list is not an Autodialer. In both cases, no matter where you are, if you're dialing using human involvement, such as there's a technology out there that allows calls to be launched simply by a human sitting in a room, pressing a keyboard button repeatedly, in a predictive sort of way, like a traditional predictive dialer, that is usually not an Autodialer. I spoke with the plaintiff's attorney this morning on another panel, and he referred, kind of laughingly but accurately, ATDS does not stand for Automatic Telephone Dialing System. It stands for a Total Disaster System. And like Steve said, that is exactly what the FCC is working on right now.
That's right, and we do. Our prediction is whatever rule comes out of the FCC on their new definition of ATDS, that also will be litigated up to the DC Circuit and may take some time to sort out. So this is very much an evolving and fluid legal situation, which is, which depending on where you are could be fortunate, and if you're, as Dan said, in California or in the Ninth Circuit, could be unfortunate. But the courts continue to wrestle with this every day, and in a lot of cases that we're working on, we can use the doubt of how the court may rule on this in our favor to drive a lower dollar settlement. That's one of the things that Dan and I have been doing over the last 6 months or so. Of all the things that Dan and I have said during our portion of the presentation, the chart that's on the screen right now is probably the most valuable thing that you can take away from us. This is a chart that Dan and I have been using for a long time. This is a summary of the type of consent that you need based on the type of call you're making and the type of technology that you are using. The things with, if you see in that second column there under cell phone, not telemarketing, the little asterisk next to prior express consent, there has been a petition on file by a plaintiff with the FCC. I think it's been a few years now that they've not yet ruled upon, where he's saying that no, even for not telemarketing, you would need prior express written consent for those technological calls. That has not been ruled upon yet, and so as of today, the rule is still just prior express consent, and that is the simple provisioning of the number. Okay, so if a customer gives you their cell phone number, that is prior express consent to use an Autodialer to reach out to them for informational messages only, such as the bank alert, the fraud alert that I was talking about earlier. But those messages cannot include any telemarketing at all.
Yeah, and so, real quickly, because our time is getting short, technology always outpaces the law, and in the last couple of years, we've seen new kinds of technologies being developed, in an attempt to avoid TCPA liability issues. You've seen different kinds of calling platforms. There's been in the last few years, a number of our clients have asked us about ringless voicemails, which are technology that avoids the cellular network and delivers a voicemail message right into your cell phone voicemail box. So your phone doesn't even ring. You just all of a sudden you have a voicemail. The argument has been that those aren't calls because they don't go across the cellular network, and therefore the TCPA doesn't apply. Florida has legislation specifically on this now. It was enacted last year. The first court case to have addressed ringless voicemail was this Saunders case up on the slide. In 2018, it said ringless voicemail are calls subject to the TCPA, and timely for this, just on Monday, the Southern District of Florida came out with a decision similar to Saunders, saying, yes, ringless is definitely a call under the TCPA, the consent rules apply. Avatar calls are calls that utilize where a live human representative interacts with the consumer but uses pre-recorded audio snippets to have a dynamic, real-time, two-way conversation. It's not a passive kind of pre-recorded message where you pick up the phone and you hear a message played and you can't yell, you can't slam down the receiver, nothing like that. right now, Steve and I are litigating this issue. It's a case of first impression. It's out in federal court in Oklahoma. We've also petitioned the FCC for a ruling on that avatar and soundboard calls are not pre-recorded message calls under the TCPA. Do not call rules, real briefly. So we spent a lot of time talking about autodialers and pre-recorded messages. There's another category of TCPA and telemarketing sales rule issues that comes up a lot. These are calls to numbers on the National Do Not Call Registry or a seller's own internal Do Not Call list. These rules only apply to telemarketing calls, but again, I think given the folks on the phone, there's probably most of you guys. You can't call folks who are on the National Do Not Call Registry. You can't call folks, regardless of how you're calling, whether it's manual or autodialer. You can't call folks on an internal Do Not Call list. What that means for a lead generator is you can't call. You in theory need to be scrubbing a call list against the seller's internal Do Not Call list as well as the national Do Not Call list. Now there are a couple of exceptions. If you have written consent, that's okay. That trumps a Do Not Call request. Or if there's an established business relationship, which is where a consumer fills out a lead form requesting a call, that is called an inquiry EBR. There are also established business relationships based on ongoing business relationships with the seller. You want to go to the next slide, Jonathan? The companion to the TCPA is the telemarketing sales rule. This is aggressively enforced by the Federal Trade Commission, but there's no private right of action, so you don't see private class action litigation. You do see the FTC imposing fines of tens of millions of dollars, if not hundreds of millions of dollars in at least one case. But this does not apply to Autodialer. It only applies to pre-recorded messages as well as calls to numbers on the Do Not Call list. It does not apply to B2B transactions unless you are selling essentially cleaning supplies and other I think, perishable office products. So if you're selling vacuums or Windex to businesses, then you need to worry about this, but most don't. Finally, as folks on the phone may be aware, there have been a lot of legislative enactments and bills introduced to deal with robocalls. I mean, a lot of people, people do not like robocalls, and so in bipartisan fashion, you've seen a lot of bills introduced to address robocalls. To me, it's a lot of sound and fury signifying nothing. These are bills really designed to expand or confirm the FCC's enforcement powers, or they expressly allow carriers to block calls that are deemed to be fraudulent or scam kinds of calls or from those kinds of numbers, but frankly, the carriers have had that power for quite some time. Nonetheless, we probably will see something passed, but I don't think it'll change the landscape too much.
And now, briefly, strategies for enhancing compliance and avoiding legal pitfalls. We'll go around our panelists, and why don't you pick one or two that you want to emphasize best practices. We'll start with Steve. In telemarketing or otherwise, if you had one thing to impart to a company that's buying or generating a lead, what would you advise to watch out for?
I would certainly advise if you're generating the lead, then I would go back to the first discussion that we had about making sure your consent is clear and conspicuous, disclosing who you are, who may be calling the consumer when they fill out that form or complete the phone call. All of that is vitally important to getting to making it a valid lead on the front end. That minimizes all the risk on the back end. If you're buying leads from someone else, get reps and warranties in your contracts that say they generated those leads in a compliant fashion, and I would even go one further to say that in the event that it's determined that they didn't, they fully indemnify you for any resulting legal liability that you may have as a result of buying those leads from them. And so those would be the two big things from my perspective.
And Alex, sometimes that indemnity may not be enough if they don't have any money or insurance. What would you advise?
Well, going back to a point I made earlier, know your lead source or buyer. Having a documented monitoring and diligence program that is, you can replicate for each new partner that enters your ecosystem, and importantly, that you can stay on top of how they're using the lead or generating the lead so that you can be proactive and avoid downstream liability. For me, the most important part of that is developing the program so that I can, can basically be on autopilot.
Dan?
So a little bit of wisdom from my late father. There were two messages that left a real mark on me. One is don't half-ass anything, and close only counts in horseshoes and hand grenades. If you are going to engage with consumers, especially over the phone, give a lot of thought to how you are going to structure your program and make sure it's compliant. Because under the TCPA and TSR, these are essentially like strict liability statutes. Getting it pretty close to right doesn't save you. Even if you're trying to do it right, it doesn't save you. So again, give a lot of thought before you engage in one of these kinds of campaigns.
Right. So bottom line for both buyers and sellers, don't put your head in the sand. Know what's going on above or beyond you, and know what happened before you, right from the beginning all the way to the end. Well, with that, I'd like to thank our panelists, Steve Freeland, Dan Blinn, and Alex McGarris. I'm Jonathan Pompan in Washington, D.C., and I'd like to thank the LeadsCouncil for helping put on this webinar today, and our team here at Venable. For more information, please check out our firm's website, venable.com, our advertising law blog, allaboutadvertisinglaw.com, and for consumer financial services matters, venable.com/CFS.